big civil affairs.
But we can also
I
just
know
do
the
something
EFF
little.
has national reputation, and I know this is one of the Austin branches, so I haven't had a chance to go to one of their homes yet.
I remember you. I'm registered with you last time.
That's not good at all.
I
don't like this.
Cultural.
Would anybody like some handouts of the talk?
Yes, please.
Go.
Thank you.
Go. Can you just share? Anybody else want a handout? Go. Handouts. Anybody else want one?
Cultural attitude on the privacy issue.
Anybody else need a handout? Handouts.
Care
Okay.
that was one of the things that protected my whole
And handout two. Handout two. Handout two. Handout two. Handout two. Cool.
Hey, there we go. So, what's the URL for where you put this?
So
Maybe I can get a page view on this one.
hell yeah.
PDF.
Oh, it wants to connect through your face. I know there's an email way to do it.
So the person didn't have a Facebook.
I don't.
I think there is an email way to do it, but I may have to go fetch them again. Oh wait, Skip, there it is. Ha, they hide it in.
Skip.
Alright, it wants an email address, Scott. Oh, yes.
Thank you.
South by Southwest.
Thanks for the delays, Bill. We'll be ready in just 1 second. Okay, thank you for connecting. Now I should be able to go to the region. Wait, no. Oh, there we go. Okay.
Of course. There it is. Now maybe it'll show up on the screen. Download it.
I hosted it, but weirdly, it's not taking me to the hosted link. Let me see. There we go. Here we
I
go.
saw that today.
There you go.
Talk to that guy.
That's a little better.
All right, there you go.
It's good to be the king.
All right. So if you're ready, I will
Go
probably
right
talk
ahead.
for a second. Okay. All right. Well, we're going to get started here. Welcome everybody to the EFF Austin monthly meetup. My name is Kevin Welch. I am the current president of EFF Austin, and we have both old and new faces. So as I always tell for the new faces, if you don't know who we are, EFF Austin is a long-standing digital civil liberties organization. We are closely affiliated with the Electronic Frontier Foundation out of San Francisco. We are a member, in fact the oldest member of what is known as their EFA, or the Electronic Frontier Alliance. The EFF and EFF Austin, we basically fight for digital civil liberties issues, things like net neutrality, end-to-end encryption, right against unreasonable search in digital spaces. You know, if it's the intersection of law, technology, society, and a bit of dash of fun cyberpunk futurism, that's probably where you find us. So, yes, this is where I give a few brief announcements. First of all, next month's meetup, I first want to emphasize it's going to be at a slightly different date than everyone's normally used to. It's actually going to be on the second Tuesday, not the second Monday. The reason for this was to accommodate the schedule of our special guest, our technical reporter, Cyrus Farivar, who's going to be here in town promoting his new book, Habeas Data. And we will be presenting this in conjunction here with Book People, who will have copies of his book for him to sign for you and get. So all of you should come, because I want Cyrus to have a successful event and sell many books. So everybody come. That should be great. Let's see, also coming up in November, we're going to be partnering with some local, penetration security researchers, and we're basically going to be doing some securing your privacy online 101, and also just trying to demonstrate with some potential live doxing how easy it is for information about you to be found out about online. So come in November for that. In December, I don't know if we'll be having a speaker yet or not. We may, but we'll definitely probably be having our usual annual holiday party, so stay tuned for more news about that. Also, we, as I told people who were at the last meetup, we are trying to find a date that will accommodate both the Joseph Kopser and Steve Kling campaigns for sort of a tech policy panel. We were initially having difficulty securing a space to do it, but we now have that. It's going to be at B.D. Riley's Irish Pub on 6th at some date. The question is finding a date that works for both Kopser and Kling and when the pub is open. I am actively emailing all of them as of today trying to find that date. So stay tuned about that. Hopefully we'll get it done before this thing called an election happens. Oh yes, there's an election coming up. And if you are not registered to vote, Marcia, the entrance there is a voter registrar. You can get you registrar. We, are hacktivists and not slacktivists. We encourage a diversity of tactics. Even if you are cynical about voting, please register and vote anyway. So let's see. Yes?
And we should point out that Marcia's accepting donations to EFF Austin back there, unrelated to her
Yes.
registration activities.
Oh yes,
So
all
if
these.
you want to donate like $100, $150
or
on
$5.
your way out.
Yes, that this is all made possible for generous donations of viewers like you. If you want to support things like our holiday party and our Fun South by events, every little bit helps. So please chip in there. Also, we are actively working on spinning up some activities for the upcoming Texas legislature. We're actually partnering with UT Law. Some of their law students are going to be partnering with us in the legislative lawyering clinic. So yeah, we're going to be trying to have a footprint there. If you are interested in being a volunteer and getting involved in that, you should speak with this man Josh at the back. He is one of the 2 board members really leading our effort there, so you should talk to him about that. Let's see, anything. Oh, and finally, I always like to open it up to the community and ask if there's anything of interest to the EFF Austin community that anybody in the audience would like to share with everyone. Shameless self-promotion is completely encouraged. So is there anything coming up that you think people will be interested in? John?
I just want to note that this EFF Austin talk and the last one by Brandon Wiley will be streamed, recorded and streamed for the Plutopia News Network at plutopia.io. So if you want to come back and revisit this conversation, or if you want to find some other cool stuff, which we also have there, that's the place to go, plutopia.io.
Great. Anybody else in here? Yes?
The Austin Forum on Technology and Society is having a talk tomorrow at 6:15, I think, at the Austin Public Library on cybersecurity. There's a networking event after. I think it's a threat researcher from Cisco.
Yes. No, we've partnered with them in the past. They screened the Trolls documentary a while back. We encourage people to go to. Former EFF Austin board member Andrew Donahoe has been a guest at the Austin Forum. So yes, they're great. You all should go to that. Yes, Josh.
I have a question, comment and a question. So we're starting to try and keep better track of like who's interested in this kind of stuff. So I've got a sign-in sheet going around. If you don't want to sign in, you don't have to. But just like start getting to know who's coming to these things, what people are interested in. So I'm going to start passing these forward. If you don't want to, you don't have to. Which brings me to my question. Does anyone have a pen? I forgot mine. Can I use it as these guys?
Here, there's some shameless stuff.
Cool. Thanks, guys.
Like that, it was long and
Any other announcements? Anything at all? It could be a cool EDM event you think we'd all enjoy. I don't care. So, anybody? All right, cool. We're good. Oh, one last thing I want to mention, which is we are partnering with a couple other affiliate groups in town and are co-presenting a few events. For instance, we're co-presenting periodic happy hours with the Operator Foundation, one of our sponsors. Brandon Wiley on their board and their technical whiz gave our last monthly talk. He hasn't yet announced when he's planning his next one, but go to those. They're a fun chance to just drink casually at Oddwood Ales and chat with your fellow nerds on these issues. And finally, we're partnering with the local indie web movement and are presenting. They're having some get-togethers now at Mozart's Coffee on the first Wednesday evening of every month. You should go to theirs if you care about getting out of the walled content gardens and not having the internet at the mercy of Facebook, Google, etc. So go there if you want to learn more about that. Okay, one last thing. November, we are partnering with Nerd Night Austin, and we will be presenting the 3 talks that month. I will be giving a talk on net neutrality. John Lukowski is going to be giving a talk on the history of EFF Austin. And Chris Boyd is going to be giving a talk about I'm not sure what yet. I'll probably find out at the board meeting this Sunday. So go to that. Okay, I think that's actually everything coming up in the near future. So without further ado, I'm going to turn things over and introduce our speaker tonight. Our speaker tonight is Scott McCullough. Scott is a technology lawyer extraordinaire. He is a former EFF Austin board member. He also is his main client is a company which a number of you may know here locally, Data Foundry / Golden Frog, who provides secure data solutions and a nice VPN to boot. Scott is going to be speaking to us about privacy as just a general philosophical and legal concept, and why we care so much about this thing and raise such a stink about it. So, Scott's a very good speaker, so I'll let him take it away.
Following up on the shameless self-promotion part of this, for those of you who are interested, although today the focus of my discussion and our discussion is going to be looking at privacy as a negative right as against the government. On Tuesday, the 18th, on Co-op Radio at about 2:30 p.m., Bob Daly and I are going to be having a discussion about the other side of this, which is privacy as against private corporations. What we can do as individuals to protect our privacy rights and interests when it comes to the likes of the Googles and everyone else that wants to get into you. So if y'all are interested in the topic, it might be something, assuming you have time, you can get into. I don't know if y'all know me. I've been around for quite a while. Been doing telecommunications and computer and information law since the 70s. Mostly in the Austin area, but I do have a nationwide practice. I usually represent service providers, but only certain types. I'm very particular about the folks that I represent. You will not find me representing an AT&T or a Verizon. I typically, although I work with them from time to time, I won't work with the Google. I'm very selective about who I represent and what I do for them. Because one of the driving things that I've had is just a personal passion, is I care about the individual. I care about people as consumers, I care about people as citizens, and I care about the impact of governmental policies on the individual. It may not surprise you to learn that my political philosophy kind of bends towards a libertarian, small L libertarian. And so I am usually in a position to say something that offends everybody. And you can probably expect that I might say something that you may not really want to hear. But you can be sure that I'm here today to advocate a position, but I'm also here today to try to help us get a firm understanding about this thing called privacy. I can argue this as a lawyer and somebody who tries cases all the time. I can argue any proposition from any side. It's just what they train us to do. And so, I can present the argument on the other side of virtually anything. When I'm going into a case, the first thing I do is put myself in the other side's shoe and figure out how I would attack a problem. And that's the best way to defend or go after somebody. By the way, mic check, is this working okay? The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as 1891, the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. Personal rights could be deemed fundamental or implicit in the concept of ordered liberty are included in the guarantee of personal privacy. That comes out of Roe versus Wade, a case that probably most of you are well familiar with.
So Fourth Amendment doesn't factor into that?
I'll get to the Fourth Amendment in a second. I'm speaking more of the Constitution generally.
Okay.
In Roe versus Wade, the court was actually looking at the entire Bill of Rights and the underlying concepts of liberty that form the basis of it. And it found that this particular right of privacy, in that case the right of abortion, arose through the penumbral rights of the Constitution, including the First, the Fourth, the Fifth, the Ninth, the 10th, and of course the 14th. And in particular, what's known as the Due Process Clause of the 14th Amendment. And so Roe versus Wade was one of the seminal cases dealing with this right to privacy, which is, as we will discuss later on, really rooted in the right to liberty, the liberty rights, which are spoken of in the Constitution and the Declaration of Independence. Now, another case, Washington versus Glucksberg, a case, by the way, which is one of the favorites of the current nominee to the Supreme Court, Justice Kavanaugh, also adds that in order for these, what we call in the law an unenumerated right in the Constitution, also needs to be deeply rooted in the nation's history and tradition. And those who are against the right to abortion often use that last prong, which was actually not mentioned and probably on purpose in Roe, as one of the reasons why the right to privacy is found in Roe, specifically with regard to the right to abortion, probably was not proper. Now, I'm not here to talk about abortion, okay? But, like the right to abortion, we as individuals have a certain set of rights, a bundle of rights that we carry around with us all the time. And they are all based on the various aspects of what's expressed in the Declaration of Independence, and then expressly stated in the first 8 amendments, 9 amendments to the Constitution, and then the 14th Amendment, and particularly the Due Process Clause. Abortion is one of them. These are liberty interests. Now, I hope to convince you tonight that information privacy, as a distinct privacy and liberty interest, is a part of a fundamental and recognizable realm of sanctuary surrounding every individual, quoting Monroe versus Pape, which was a 1983 case brought by African Americans whose house had been invaded by the police. They were given a remedy in that case. That the right to information privacy is implicit in the concept of ordered liberty and deeply rooted in the nation's history and tradition. I contend and I'm not alone, I contend that information privacy meets the test for so-called unenumerated rights and is protected from arbitrary intrusion by the police. Let's see how many agree again. I put together quite a few pages of historical and other references, and we may flash them on the page. But let me tell you something, I'm not going to give you death by PowerPoint tonight. I'm not going to read from all this stuff. I'm hoping more to have kind of a guided discussion. I'm going to introduce some of the topics using the headers on the first couple of pages. I don't know if y'all have my paper, either hard copy or online. I'm going to introduce the topic.
If you don't have one of the hard copies, you can go to effaustin.org/resources, and there will be a link to his talk there, a PDF of it.
And then we're going to talk. And there's a lot of different ways to look at this. For example, one of the source materials that I use, I'm not sure I cited it in this, is the Stanford Encyclopedia of Philosophy. They have a really good paper that I would commend to you that looks at privacy from a philosophical and ethical point of view. And of course they address the law. One of the modules in there is the feminist critique of privacy. Now, what do feminists have to say about privacy? Those of us who are in the digital arena and really zealous advocates of privacy might be surprised to learn that many feminists are not really excited about the right to privacy. They think it can be used as a tool of oppression because it keeps secret many of the offenses which have been, and power plays which have been portrayed against women. And there is an argument for it. There are others who argue against privacy. One of the most notable was, of course, Robert Bork, who did not make it to the Supreme Court, largely because of what he had to say about privacy. Another, an economist by the name of Richard Posner. I don't know, those of you who follow economics, Posner has a view about privacy. He thinks privacy is inefficient. And indeed, individual privacy is contrary to the liquid of commerce. And that only the privacy rights of corporations should be honored, and not that of individuals. I would disagree, but the fact of the matter is there is a range of views on this topic. So, what's privacy? Why is privacy important? Everybody got any ideas? I can give you now.
The right to be let alone.
Well, that is one of many. Let's see if that works. This ain't working.
Let's see. So, is it just an image? Take a look.
Go ahead and close it.
And that's enlarging. Okay, so let's see if we do that. Is that
There you go.
okay? And I think if you just do, okay, you can.
Yeah, just scroll down.
You can do
All right,
that.
here we go.
Okay.
Yeah. Okay. Let's start with why privacy is important. Now, I've given you my suggestion here, hopefully in relatively concise form. I think that privacy is important because it supports individual liberty and autonomy. We're all autonomous people in this world. We have the right to make individual decisions about ourselves, how we will conduct our lives. One of those decisions is the kind of information that we wish to keep to ourselves and share with others on a limited or on a wide open basis. Privacy, in my viewpoint, also has very much property implications. We own ourselves, just like a woman owns her body. And that is one of the bases that the court found in Roe. The abortion actually is reflective of a property interest. So we own our body. We own our decisions. We have a right to decide what we will share with others. It is within the bundle of rights that comes with privacy. The terms and conditions upon which we will allow others to obtain and use information about ourselves. Finally, just from an ethical and philosophical perspective, privacy provides functional benefits because it advances the human condition and it preserves ordered, polite society. Aside from the law, you know, what do you often hear from people? Mind your own business, right? Good fences make good neighbors. Why? We're respecting each other's privacy. If you start invading somebody's privacy, they get angry. Somebody starts looking in my window, especially my bathroom window, while I'm taking a shower. I'm not too happy about that, and I'm likely to do something about it. Well, so there's a reason for this. We have an innate sense of self-determination and a right to control our bodies and those aspects of our bodies and the aspects of our life. So just from a ordered society perspective, privacy is important. Boy, my program really does not like this. All right, so what is privacy? Somebody said something a little while ago, and they said the right to be let alone. Who's it? You did. Very good. By the way, that's right here. Judge Cooley, Warren, and Brandeis described the right to privacy as the right to be let alone. Now, the context that they were talking about was in the legal context, and specifically at the time in their seminal paper from the 1890s, the right to privacy, they were talking about the civil tort of invasion of privacy. They were recommending that the common law, not the statutory law necessarily, but the common law, recognize a cause of action. And they've now, Dean Prosser, characterized them into 4 types. Okay? Actionable as against someone, another individual on the civil side, that violated your right to privacy. Prosser went through all of what Warren and Brandeis and some of the common law had said, and he identified 4 distinct torts, which is a cause of action. I can sue somebody under tort. Intrusion into solitude, publicizing private facts, false light, portraying you in a false light, using what even may be factual to put you in a position that isn't true, and appropriation of name or likeness. And so, in a legal sense, the right to privacy is indeed the right to be let alone. But there are others in the non-legal context who have described it in different ways. Let's see. There are some who describe it in terms of information control. If we're talking about the right to privacy more globally, that's not entirely correct because there are other privacy and liberty related interests that are about more than just information. Abortion being a good example. Privacy is the condition of not having undocumented personal knowledge about one possessed by others. Similarly here, it's about intimate decisions about intimate access. That was actually reflected in a Supreme Court decision called Griswold versus Connecticut, which dealt with the right to contraceptives, predated Roe. And if you take a look here, I have given a hard link to a paper which defines all of these. And those of you who are interested in the Stanford material that I cited, here's a hard copy of the same thing. So, one of the problems that we have in the legal context and even in the societal context is there's not really a uniform definition of what privacy is. It can be a big thing or it can be a little thing. It can be about information. It can be about decisions. It can be about a host of matters. And so, ultimately, privacy is something that can really be, is context specific. One thing about privacy as it has been considered over the years, and trust me, people have been talking about this concept for a very long time. The actual derivation of the term has specific meaning. Let's get here into this. Private and privacy derived from the Latin privus, meaning single or individual. And so private is the opposite of public, and therefore involves something separate or not involving the public. And the public in this context can either be the people, other people, or the state. So there is this dichotomy. There is that which is about the individual and about individual decisions and facts, and then there is the outward facing view of a person within the greater realm. This was the way that ancient philosophers looked at it. For example, Aristotle. Anybody doesn't know who Aristotle is? Aristotle distinguished between the public and the political sphere. He called the political sphere the polis, and the private sphere of the family the oikos. And he was one of the people who first decided that while you are in the public sphere, you have lesser rights and you have certain obligations within society. But once you come back within the oikos, you have a different set of rights, duties, and obligations. And the way that you look at a situation will often depend on whether we are dealing with the polis or the oikos. Others picked up on that. St. Thomas Aquinas. Anybody aware who St. Thomas Aquinas is? Go ahead.
He was a Catholic theologian who formulated natural law theory.
Very good. That's exactly right. Dang, I should have talked to you before I put this together. St. Thomas Aquinas, during his time, the Roman Catholic Church had very much gotten away from the old Greek philosophers' way of doing things. And what Thomas Aquinas was trying to do was reconcile the two. And he developed this theory of natural law. So, like Aristotle, he advocated for individual reason in pursuit of virtue. He believed that the natural order of justice limited rulers' authority. And even rulers must obey the law. The state has no power other than that which is given to them by the people. And he believed that if a tyrant arose, it was incumbent upon individuals and the rest of society to depose that tyrant, even to the point of sacrificing oneself to do so. That was an act of virtue. But what he was describing was a set of rights as well as duties that every individual had. Now, of course, he put this in a religious sense, and in terms of communication with God. But the rights that came down from God in a natural law sense were those dealing with the individual as against society in general and the government in particular. John Locke in the 1600s from Great Britain also picked up on natural law theory. He too used this public-private perspective that had first been articulated by Aristotle. He perceived privacy to be a property interest. And that is important if you begin to listen to the legal scholars of today discussing whether privacy is a right protected by the Constitution. You will see a lot of discussion in it if you happen to read the most recent decision by the Supreme Court in the Carpenter case. One of the justices who dissented, newly installed Justice Gorsuch, he dissented from the decision protecting cell site location information. But he would have protected the information too, just using a different theory. He thought this information was, in fact, the individual's property and protectable as such, whereas the majority of the court decided to adhere to what's known as the old reasonable expectation of privacy test, and they chose to not extend the so-called third-party doctrine to it. Now, to me, that was a lot of just careful dancing. I'm actually quite attracted to Judge Gorsuch's theory and approach, and we're going to come back to that in a minute. John Stuart Mill, not often thought of as somebody who was a natural law theorist. In fact, he's known more as what's called an act utilitarian, someone who believes more in positive law, man-made law, as opposed to natural law. He too, however, advocated in favor of individual rights and individual privacy. And he too used this public-private distinction to do so. Even act utilitarians, if you press them, will recognize that there is a zone of individual privacy that needs to be respected. They come to this conclusion, however, for purely utilitarian purposes. They don't do it for moral reasons. They do it because it's efficient, because it reaches the right outcomes. So there is a broad spectrum in philosophy and theorists in moral law respecting the need for an individual to have control over themselves and including information about them as against the rest of the world, and in particular as against government. And our founders well knew this. They did. The founding documents of our country are replete with references to individual liberty interests, privacy interests, and rights as against the government. For example, James Madison, he often expressed Lockean views. He believed that a person's ideas, beliefs, and abilities and the opportunity to exercise them are the most treasured property. Notice how I keep coming around to property. To me, privacy is property. Information is property. And our founders recognized that. A man has property in his opinions and the free communication of them, said James Madison, and has a property of peculiar value in his religious opinions and in the profession and practice dictated by him. Back then, of course, religion was really the moral code by which people lived. And so we should not be put off, those of us who may not be particularly religious, should not be put off by the religious tones used by our founders. They were really talking about morality. The safety and liberty of his person, his property, very dear to him. A man is said to have a right to his property, and he may equally be said to have a property in his rights. Thomas Jefferson also should be familiar to all of us. He often explained that the words he wrote in the Declaration of Independence about the rights to life, liberty, and the pursuit of happiness were written into the Constitution and in particular the Bill of Rights. Indeed, he always contended that a primary purpose of the Constitution was to put in very specific words that set of rights to life, liberty, and the pursuit of happiness. It is to secure our rights that we resort to government at all. The very purpose of government, according to Jefferson, was to secure individual liberty. John Adams, similar times, expressed similar views. Rulers, he claimed, are no more than attorneys or agents sent away to protect our individual interests. And the people, if they betray this trust, the people have to revoke their authority and substitute other agents who will act to protect individual liberty. Alexander Hamilton, you know they ought to write a play about him, discussed the principle as part of the debate leading up to the Constitutional Congress. He too spoke of and invoked natural law with reference to the right to privacy. Those of you who are interested, I think I have it here. those of you who are interested in, can look at some of the material. Hello. You can look at some of the material. You can look at some of the material that I cited, and again, I've given hard links to it. There's a really good paper from 1949. The Founding Fathers and the Natural Law, Studying the Source of Our Legal Institutions. I pulled much of the foregoing information from it. It's old, but it's still valid authority. So, let me talk about natural law for a minute, although if you want, I can talk about it from a utilitarian perspective as well. Does this natural law right, as discussed by the ancients and put in place by our founders, can it actually act to supersede man-made law? Positively. The answer is yes. The easiest way to describe that is, say you have a state statute that says the police can knock down your door and steal your papers without a warrant. Well, obviously, that would violate the Constitution, which derives from natural law. But there are other instances as well. Roe v. Wade, again, to return to that. And again, I'm not here to debate abortion, but I use Roe v. Wade because many of us in the law recognize as a practical matter that that's not only just precedent. There's precedent on it. It's almost super precedent. And so the things that the court said in Roe versus Wade can often be used and applied to other topics. Yes?
Can you talk a little bit about the difference between man-made and natural law? How's the Constitution not, you talked like the Constitution was derived from natural law. How can you have any sort of sense of natural law without a sense that there's some higher power that, bestows things upon you?
Well, natural law does not require one to believe in a deity. Natural law can be entirely justified on non-religious terms by appealing to reason. And those of us who like to apply reason in a logical sense without having to try to believe in some mystical being can quite easily get to the same place as those who believe in natural law. You simply follow reason in the pursuit of virtue. Now, if you're asking me, and I think where you were going is, well, isn't the Constitution
Just as man-made as any law passed today?
Yes.
A greater precedent because it's been around a lot longer, but
Isn't
still
it just
man-made.
positive law because we made it?
Technically, it is positive law, and certainly there are many aspects of it that are. The parts that discuss separation of powers, for example, Article 1, 2, and 3 in the Constitution itself, yes, that's positive law, you bet. Now, I would say, however, that the Bill of Rights, which was added as a result of the first Congress after the Constitution was adopted, that is really just an expression of natural law. It was written based on natural law principles. Yes?
There's a famous quote by Abraham Lincoln describing the Declaration of Independence relationship with the Constitution. I think he was quoting Proverbs from the Bible that the Declaration is the golden apple protected by a frame of silver. The frame is not supposed to hide the apple, but it presents it, because that's the relationship they were supposed to have together.
Yes. Yes. So technically speaking, yes, the Constitution is positive or man-made law, but its underlying principles derive directly from natural law, especially the First 10 Amendments. Yes?
So I'm interested in your sort of framing of what is natural law. So I want to throw you a supposition to see if I can trick you. Suppose, I'm forewarning, suppose that tomorrow we've come up with these very good scientists have found that, in fact, it is better for human beings to live in a village, and therefore privacy should be, by natural law, as natural as it can get. The biologists have determined that, in fact, we should have no privacy, and privacy should be banned outright, and that any privacy is bad. So would you change your view?
No.
Why? If natural law, if the Constitution derives from natural law, or if natural law is sort of the framework or axiom of which we base our decisions, and they've said that this is natural law, why does not everything follow?
First of all, one of my subspecialties is cross-examining expert witnesses.
You have my permission to cross-examine the witness.
Well, actually, I'm not going to cross-examine him. I'm making this only as to point out that almost every scientific theory has a logical flaw. And before I would accept such a principle, I would like to see the basis for these conclusions. And I would like to have the opportunity for it to be tested rigorously, not necessarily by cross-examination, but perhaps by a standard scientific method of replication, peer review. I'm not so sure that you would get a lot of agreement to that, especially those who like to live in the country.
So,
Like me, yes.
I guess this is kind of divergent from that. So would you say that this natural law implemented in this frame, as we were speaking about, that would be shifting the ownership from the individual to the state?
What I'm trying to suggest, and there's a little bit more of this later.
So the state owns your rights and then therefore
Well,
grants them back to you.
The point is, we own our rights, and they are inalienable. Our rights are inalienable. The government is there only because we have allowed it to be there, only because we have created it. The government is not there to rule us. It is there for our convenience. They are our agents. We are their principals. And so the government does not give us rights. We have surrendered some rights in order for there to be ordered society. And the question is, how far need that go? So there are numerous cases where the Supreme Court and the Supreme Court of other states have found that natural law, and in particular some of the inalienable rights expressed in the Constitution and the Bill of Rights, can operate to supersede man-made law. It goes as far back as 1886, where the court was providing a remedy for an unlawful entry, warrantless, by the police and their pillaging. At the time, of course, we had the warrant requirement. But there really was not yet a remedy. The court had not yet, for example, come up with the so-called exclusionary rule, which forbade the admission into evidence in a criminal trial of the fruits of a warrantless entry. Nor had the court completed the process of extending all of the 14th Amendment due process provisions to the states. And so when Ohio, for example, when Ohio agents broke down somebody's door and made off with all of the goods, not only did the court condemn it because of the Fourth Amendment, they also gave these particular people a remedy, very reminiscent of what we now call 1983. They were able to sue in tort those who broke down the doors and recover them. Now, you remember when I started off, the first thing I read, that the court has said that these unenumerated rights are not unlimited. It is only those that are necessary to ordered liberty and well recognized in the human condition, especially that led up to the Revolutionary War times. So it's interesting to take a look at what ancient law did with regard to the right to privacy. You may be surprised to learn that Roman law actually protected the right to privacy. One actually had the right to seek recompense against those who did come and take your property and invade your privacy. Invasion of privacy wasn't called that at the time, but it was an actionable thing in the Roman courts. Not only as against the government, but also as against others. There's a case out of Georgia from 1905 where it's a beautiful opinion, by the way. Y'all ought to see it. I've got it linked here. It's the Pavich case, where the court goes through and draws a line from Roman history and discusses the Roman civil code causes of action for the right to privacy. And by the way, once again, they weren't just talking about the recovery of items that were taken. In Roman law, one was also able to get relief from somebody who would be peering in your windows, acting in a voyeurish manner. There was a remedy for it. It was a recognized right to privacy. In Great Britain, British common law accepted that. Yes.
So I guess this is really interesting, but I guess I'm kind of curious about not the what of what the laws were, but the why. So, for instance, to prevent someone peering in your window, right? This is ancient Roman law. Why was it that way? Was it because these were inalienable rights? Was it utilitarianism, where we wanted the greatest amount of good for the greatest number of people, is to prevent harm to your property? Is there any, do you know what the actual reasoning behind, again, the theory of the law, not the letter of the law?
I think, especially in the Roman law context, because that was a civil code, it was not a common law code, it was a civil code, it was more of a utilitarian perspective. The authorities recognized that in order to maintain ordered society, it was important to protect the abode and the small few things that even the lowest Roman citizen could accumulate at the time, from having someone of equal stature or higher stature come in and make off with it.
Right.
So it probably was more of a utilitarian perspective than anything else, necessary for ordered society.
And I mean, I can speak a little bit that at least with some ancient philosophers, some of the Greek ones, I believe there's often a thread that, there's very much a lot of them emphasize trying to cultivate virtue. And there's this idea that virtue can't be coerced, it must be cultivated personally. So somebody only acting good in public is not actually displaying virtue, as it were. So.
And that seems to me more man-made law, or more natural law.
I mean,
right?
that could be argued a law of social mores, sure. But yeah, at least I know that Greeks, I think, often came at it from that perspective, but I'm not an expert, just from what I've heard.
Which is interesting to me that like different ancient societies arrived at privacy maybe from different theories, right? I mean,
Well, one of the later modules, which we may or may not get to here, okay, actually talks about the efforts that have been made over time to protect information from others' eyes, including, codes. And all societies, whether it be the Chinese or ancient India or the Assyrians in the Middle East and in the Persian area, all of them found it necessary to find ways, using codes and other means, to hide or otherwise protect information from prying eyes. And so I would submit that virtually every society, not just the ones that the old white people from European societies that we like to look at, but all societies from throughout the world have always recognized the need for there to be some form, some measure of individual privacy. So let's just get to that now. I'm going to run through this because I'm probably in a room of people who know far more about this than I do. Okay, but there have been efforts throughout history to protect information from prying eyes. You know, cryptology is Greek for hidden words. And the goal is to keep a communication secret from all but the intended recipient. Anybody here who isn't well versed in cryptology? Because I can run through the basics, but if all of y'all know this, I can just skip this, all right? So we all know that there's ciphers, codes, and concealments, right? All right, good. The early Chinese leveraged the ideographic nature of their language to hide the meaning of words. That was a form of concealment. In India, early rulers used alphabetic substitution codes through phonetics and often communicated the message using sign language. The Kama Sutra has a section on how to cipher with your loved one. The Sumerians and ancient Egyptians used cryptography, and sometimes compounded by substitution between cuneiform and hieroglyphics. The Mesopotamians, Babylonians, and Assyrians used cuneiforms to encipher during the same period. Hebrews did substitution ciphers using the Roman alphabet in 1600 BC. The Spartans used transposition ciphering in 500 BC. In 499 BC, Eustachius employed concealment by shaving the head of his most trusted slave and then tattooing a message telling Aristagoras to revolt against the Persians. You had to wait till the hair grew back before it would work. That was a form of concealment. During the 15th and 16th century, ciphering and codes considerably advanced with means to encrypt and break codes. Mary Queen of Scots died because she used an ineffective form of cipher. Queen Elizabeth. Queen Elizabeth, your chief code breaker, broke the code. Off with her head. The British and American revolutionaries used, both the British and the revolutionaries, both used codes during the Civil War. In fact, there's a substantial argument that can be made that we would not have won in the Revolutionary War, but for encryption.
The great TV series, Turn, Washington Spies, the House of the Sulphur Ring.
So, you know, my response to those, like we have just most recently heard reaffirmed once again, demanding a backdoor to encryption, that, you know, we've got to give up a backdoor so that the government can get in either with or without a warrant. You know, my response to that is, well, you know, King George would have loved to have that back in the day. Thomas Jefferson used codes. He even invented a wheel cipher during the time he was ambassador to France. Indeed, his wheel cipher was reinvented by the military and was the basic code that was used between 1922 and 1945. The most famous, of course, is the Enigma machine, which was broken. What many fail to remember, however, is that one code which was never broken was the use of Native American and Basque code talkers. They used a form of obscure languages and dialects with strategic word substitution. Today, most encryption is done electronically. I'm sure, again, all of y'all know how to do that. One of the big topics of the day is the extent to which normal, ordinary people will be allowed to protect their own information as against the government using encryption. Whether the government should be allowed to access encrypted information while in transit or while in storage, and if so, upon what conditions. So let's talk about that. Now I'm gonna very quickly run through some of the law on encryption, and in particular whether somebody can compelled to disclose the key. This law is evolving quickly. There was a recent decision just a couple of weeks ago that is really, I was fascinated by the decision. The federal courts have actually a mixed record on this, and they often turn on some very arcane legal principles that make no sense to a normal human being. But in the most basic terms, let's just kind of analogize the encryption key to the key to a lock. Okay? If you have a lock and a key, the government can't just come and break that lock without a warrant. But can they make you give them the key so that they can open the lock with a warrant? The answer is yes. Yeah, they can make you give them the key. Well, doesn't that violate the Fourth Amendment? No, not if there's a warrant. No. Does it violate the Fifth Amendment? No, because the Fifth Amendment is self-incrimination. It protects only the use of your mind, the conveyance of information. Yes?
What if that information, instead of a key, is more like a password, something that is only contained inside your mind, that cannot be accessed any other way? You never wrote it down. There's no other way they can get it than physically compelling you to spill the contents of your mind.
The first answer is, if you must use your mind in order to convey the information, here, a decryption key, then you cannot be compelled under the Fifth Amendment to disclose it. But there's an exception. And the courts love it. I hate this exception. It's called the foregone conclusion doctrine. If law enforcement can prove that it is already a foregone conclusion that the information that they want you to have to give the key up for is yours, and they already pretty much know what it says, pretty much, okay, then you can be compelled to disclose it under most of the cases, both state and federal. So you have to be very careful about the foregone conclusion exception to the can't make you use your mind approach to the Fifth Amendment. Yes.
Has the Supreme Court upheld the foregone conclusion?
Yes.
And under what justification?
First time they did so was actually in a case involving Aaron Burr.
Really?
In fact, modern foregone conclusion law, as it was originally being developed, was based on the Supreme Court's decision in the Aaron Burr case. And it wasn't because he had a shootout with him. Yes, he was using encryption, which he had dictated to his aide, in order to supposedly enrich himself with regard to the sale of land out west. Jefferson, who was president at the time, I believe, got wind of it, and there was a criminal case. They hauled in his clerk and tried to force the clerk to give up the key. And without going through all the wordy words that they used back then in the Supreme Court decisions, basically said, well, it's a foregone conclusion, we know what this stuff is. So, yeah. As it turned out, however, they still couldn't get the information. When the clerk actually began to testify, he said he couldn't remember. So, the foregone conclusion doctrine is a real problem. There's really only one way to protect information, subject to this really interesting case I'm going to discuss in a second. At least under the federal court decisions, there's really only one way to make sure that the government can't compel you to give up the key. Don't tell anybody that you got the file. Okay? Don't tell them. Don't tell anybody what's in it. And don't tell them that you're the one who encrypted it. If law enforcement cannot prove those three things, then the foregone conclusion doctrine is not met, and they cannot compel you to give up the key. By the way, by way of technology, I hope all of y'all are smart enough to know that all of these new methods to unlock phones and even to decrypt information stored in transit using biometrics, that's not going to save you under the Fifth Amendment. Forcing you to look into a phone is not testimonial, it's an act. And so if you have your information locked up or encrypted using a fingerprint or other biometric information, Fifth Amendment isn't going to save you. It's only a key that's in your head and can reveal only by information in your head that you must speak.
And there is, I think most people in here know, at least Apple has built that into it, has acknowledged that, and so I think it's if you press 5 times on here, it removes, it resets the fingerprint password, and so you'd have to enter your actual password in.
Basically, Apple has provided that if you want to use the fingerprint for convenience, but you suddenly find yourself in a situation where you need to lock it down to passcode only, there is a quick way to do that. So, yes, I believe that is correct.
Do your own research, but I'm pretty sure it's 5 times.
This is an interesting hypothetical, Scott. Based on current lines of research, they're eventually going to be able to read our minds. Can they compel the key if they could read it as the thought in our mind?
Well, interestingly enough, that sort of gets us to this case that I've kind of given hints to.
Has the Supreme Court looked at language?
I'm just telling you what DARPA's working on. They're actively working
Well,
on it.
and in fact, I have read of studies where they actually now are able to tell, what sorts of things you're thinking about.
I saw a dude from DARPA at last year's Body Hack Con actively demonstrate that they were able to figure out thoughts inside people with dementia's heads that even the person with dementia didn't know they had anymore. So the tech's coming along. It's getting mature.
They're gonna be real unhappy when they get to my
Oh, I know, it'll blow up the machine. I don't know what's going to come of this. It's a really relatively, it's a very recent court case out of Indiana. Those of you who have my paper, it's discussed on page 16. It's called Sayo versus Indiana. Brand new argument in favor of Fifth Amendment protection, and it's based on technical grounds. It's completely separate from whether revealing a key is testimonial. The state appeals court found that forced decryption requires a defendant to recreate the information the state is seeking. That's testimonial. Remember how encryption works. What encryption does is it scrambles all the information so that you cannot, somebody who is looking at it cannot determine what those ones and zeros represent. In digital form, the information isn't a word. I mean, we all know this, but we don't think about this very often. It's what the ones and zeros represent that has meaning. And so the act of first encrypting and then second encrypting is actually a reordering of information and a changing or a hiding or unhiding of what the information represents. And so what this court was saying was that by the act of disclosing a key, not only is that testimonial, it allows the state to not find the information, it recreates the information. For those of you who understand something about the law of evidence, in other words, it's hearsay. Now this seems eminently technically correct to me, and it is not something I have thought of. I've dealt with these issues. I've studied on these issues forever. We were all hung up on whether disclosing a key was testimonial. But what about the act of decryption itself being testimonial? This court found that it is. So, no, federal courts haven't addressed this. This is a brand new thing. I've never seen it before. Nobody I've talked to has ever thought about it before. Some genius came up with it, and the Indiana court bought it. It's a great opinion. I commend it to you. Maybe those of you who are real geeks and understand how encryption works can articulate in better terms what I'm trying to say.
You pretty much said it correctly.
So to put that back to a, I guess, a more physical analogy, if the act of decrypting is recreating information, would shredding documents, or I don't know, just inserting a whole bunch of ones in between the figures of a paper, and would trying to recreate that information, would that be testimonial in the same way? Like anything that you do to, I don't know, this to shred, to get rid of evidence, and if that the state can recreate in a physical manner, would that be testimonial in the same way that decryption is?
It would be, but remember what we're talking about here is whether the person who asserts or has ownership of it, or at least arguably created it, can refuse to help the state. Now, if the state can independently figure out what this stuff is, as the federal government did in the San Bernardino case with regard to the Apple, remember the iPhone that the San Bernardino killer used, and it was all that litigation. I was in that case. It was fun. We had a great time, and we thought we had a really good case. And then all of a sudden, the federal government just went away, right? Because they found somebody that could decrypt it. Now, from a legal perspective, the question within SHIFT is no longer a Fifth Amendment question. Okay, it's no longer a warrant question. The question is whether the government can show with clear and convincing evidence that this recreation is what they say it is, and is in fact a faithful recreation. And quite frankly, I'd have a good time talking to them about that. I'd have a really good time talking about that.
Well, I mean, yeah, the technology person in me is now thinking of all sorts of fun arguments about the hash function used to restore it and whether if it guarantees uniqueness or not. Because maybe this is some random string they put together that via their decryption algorithm says what they want it to say. You can construct such algorithms.
Yes, you can. Although I will say, I'm not real pleased with it, but you know, in the copyright area and in the child pornography area, one of the ways that the state is proving up its case now is by using hash values, recognized hash values of child pornography. Yeah.
They're literally building a rainbow table of known sources.
Yeah, and once again, you know, I could imagine the fun I would have talking to the expert who can testify that this is in fact a true and correct conclusion. But it is ultimately just an expert conclusion. And hopefully it would end up going before a jury rather than being decided as a legal question before the court.
That sounds kind of like the Napster case, right? They take the music and make an electronic file of it. Is it really the same song, or is it something new that the person's created, right?
I mean, it's actually very much analogous in the sense that one of my favorite arguments Cory Doctorow gave to illustrate the absurdity of current copyright law is he basically said that you could, on a Linux system, you could copy a media file and direct the output to be saved to the null pointer, which basically deletes the data stream immediately. And so if you did this a million times, you would still only have one song, but under current copyright law, you're liable for billions of dollars in damages now.
Well, I still have my CESS tie. I don't know if you guys remember that one, right? The CESS on copy protection for discs. All the lawyers in the case were prohibited from discussing the formula in open court, and so we all had a tie.
Oh, this was the forbidden number you couldn't say.
CESS written out in pearl. I still have that. We're getting a little short on time, and I really do want to, move on and also save time for discussion. Let me just try to tell you something, and let's just be straight, okay? If you got something you don't want people to see, especially the government, don't write it down. Don't share any of it. Okay? It's not a secret if more than one person knows it. There's no absolute certainty once you share any information about it. If the government can prove through testimony or otherwise that you have admitted ownership and possession of a document and that you were the one who encrypted it, they can compel you under the foregone conclusion, at least under current law, the federal court law, to disclose the key. Now, I like to talk about information privacy as a discrete privacy right. It is different from what some of the others that we opened up with talked about with regard to the privacy right. But, you know, it's very similar in the same way. We're talking about information about you or information that you have created or shared and the extent to which you get to control it as against the government. So information privacy is a specific unenumerated right. There's lots of twists and turns to it. But, you know, there's kind of a stair-step analysis. First of all, like regular paper in the home, you know, regular papers and effects as discussed in the Fourth Amendment. If you've got it in your house, government's going to need a warrant. It's protected. But what happens when you go out of the house? Okay, you've got it in your cell phone. Well, up until recently, the case law was that the law enforcement could get to it without a warrant. But thankfully, the Supreme Court recognized that these cell phones that we carry around are really contain far more revealing information than virtually anything else. And so relatively recently they ruled that the government must get a warrant to crack your cell phone. Even in the context of a custodial search. Do y'all know what a custodial search is? No. It's a search incident to arrest, basically. Even in public places, even in the subway. One exception, potentially, in the border. We often talk about the border being a constitution-free zone. And sadly, in the law, the border is getting bigger and bigger and bigger, including all ports of entry and all airports.
Isn't it like 100 miles now? It's 100 miles now,
yes.
isn't it?
How much of the U.S. population lives within 100 miles of the border?
A bunch.
2/3.
Like a majority.
Two-thirds of the population basically lives in the
there's like
constitution-free zone.
And that border zone, that was created, if my knowledge is correct, that was created through through executive orders, not through any act of Congress. Isn't that right?
Well, yeah, this is all judge-made law. And I think we're going to be seeing some cutting back on it.
Yeah, I was just wondering if someone tried to sue, I don't know, Department of Homeland Security, border agent. I'm not sure who you would sue, but if that got to a court with the court, is court likely to uphold it? Is that like established that's, you know, legally is that very established, that border zone, that 100-mile border zone, or could that be challenged?
Well, I think, and here I am predicting, okay? But I think that the court would extend Riley, which was the cell phone case, to other digital media such as laptops and storage media. And I think they would probably also apply it within the border zone. If presented with a proper question, I think they're going to subject that to Fourth Amendment protection. I think they are. And you can see that beginning to happen in the lower courts. The Ninth Circuit and the District Court in the D.C. and Columbia have both basically required a warrant standard. They said it wasn't, but it really was. The Ninth Circuit, for example, held that prolonged or intrusive border searches require some basis for suspicion of criminal activity. The D.C. District Court applied a probable cause standard to border searches and refused to apply a custodial search exception, in part based on Riley, the cell phone case. So we're beginning to see the lower courts chip away at this so-called border exception. They were waiting for something like Riley to kind of give them the excuse to do so. So I'm hopeful that over time, this border exception will go away. Yes?
Does that extend to all electronic devices, like your computers and your car and your watch and everywhere else surrounding you that have your personal data? Like how, I'm trying to read the law a little bit, but can you illustrate?
That's a really good question. And let me try to answer it, okay? Lots of caveats. Riley was a cell phone case, But the logic of Riley come on, laptop, right? Portable storage, thumb drive. Come on, same. We carry it, it's the same type of information.
But I take it has to be an electronic device you have personal ownership of. Like if my phone communicated with NFC with a device, any data sent to that device would not be covered under Riley.
That is where I was fixing to go. Very good. And it allows me to launch into my critique of the third-party doctrine. Okay. If you are talking about information that is possessed by third parties or over which they have some right, then I think there's going to be a bit more time until we get there. Notwithstanding Carpenter. Okay. Strangely enough, I would predict that if we get another justice on the court, like Gorsuch, perhaps like Kavanaugh, I know many of you will shudder at this thought for other reasons, and that's fine. Okay. But if we do, I think you would find in relatively short time, you would find more protection of information privacy as against the government. There's some question with Kavanaugh as to whether he would have a national security exception. Okay, but Gorsuch is firmly in the property, digital information and property. He views people who have information about you that was created on a contractual basis with you or that you give to them for storage. He views them as mere bailees of your information, and they have the duties of bailees to protect that information, even as against the government.
Baileys?
They must demand a warrant. Yes.
Can you tell me what baileys?
A bailee.
Bailee.
Okay, a bailee. I entrust my laptop to you for storage for a week, and I pay you to do so. Keep it on your shelf. We do a contract, oral, otherwise. Okay. I am the bailor, you are the bailee. Similarly, short-term storage. You know, where you go rent a shed, put your stuff in, they're a bailee. Okay? You form a contract with them, doesn't have to be written. Okay? You form a contract where they are entrusted with, okay, I entrust you with my property, and you promise to take care of it. You are a bailee, and you owe a duty to me to protect that information from all comers, including the government. And in that situation, much like in a hotel room, which is a form of bailor-bailee relationship, okay? Law enforcement must get a warrant before they can get that information. They cannot obtain it on a mere subpoena. And so Justice Gorsuch, for example, would require a warrant for information such as cell site location information, but also for other information. If you read his dissent in Carpenter, it should give you great hope that maybe even the conservative justices of this court are beginning to realize the importance of digital information to individual liberty, at least in summary.
Well, I take it that while you might think that Kavanaugh would continue Gorsuch's views on the government with data, given his views on things like net neutrality, you wouldn't count on him protecting us against corporations and the appropriation of our data quite as much.
It is true that he was not so happy with the FCC's 2015 net neutrality decision. You know, every justice is going to be a mixed bag. I'm here to talk about privacy. Right? You want me to talk about net neutrality? I'll go back and talk about net neutrality. You'll hear me singing different praise of different people and saying bad things about some of the people I've been praising today. Yes?
Can you talk a little bit more about Gorsuch's dissent and in that I was wondering? So talk a little bit more about Carpenter and about how the two different sides arrived at different decisions, and you know whether it be third-party doctrine or more on the consumer, like ownership. Can you
Yes.
can you go into that a little more?
Let me back up a little bit and kind of backfill. Somebody remember what time it is?
It's 8:23.
Oh my goodness.
We have the room till 9, so.
Okay. Allow me to talk for just a minute. Third-party doctrine has actually a relatively short history in jurisprudence if you look at things from a broader perspective like I do. Let's start with the Brandeis article from the late 1800s, where Brandeis was articulating the right to privacy. Now, as I mentioned earlier, that was in the civil context and civil tort. By the time he got to the Supreme Court, there was a case called Olmstead, where the federal government was wiretapping an individual. And the Supreme Court held at the time that that was not a violation of the Fourth Amendment. Brandeis dissented. And he tried to adapt his original right to privacy theory in the civil context into the Fourth Amendment. And his dissent, over time, kind of matriculated through the lower courts and ultimately got back to the Supreme Court and ultimately began to be the majority view about the right to privacy in the Fourth Amendment context, and after that, in other contexts as well. In fact, you can draw a direct line from Brandeis's dissent in Olmstead to Roe versus Wade.
And what was the decision?
Roe versus Wade. Yes, you can. He was articulating a right to privacy in his Olmstead dissent. That perspective ultimately won the day in another case called Katz, where the court overruled Olmstead and said that a wiretap does violate the Fourth Amendment, and the federal government does need a warrant to effect a wiretap, at least insofar as it captures the content of the information being conveyed. And the way that it worked was, again, using the Brandeis formula. They said that for constitutional reasons, if someone has a subjective expectation of privacy, and that expectation is one that society is prepared to accept as reasonable, then this is a privacy right that is protected under the Fourth Amendment. And so, for the very first time, the court began to find a Fourth Amendment right to information that was unassociated with the traditional law enforcement beating down the doors and coming in and stealing your papers in effect. This expectation of privacy could actually travel around with you, because Katz was not in his home at the time. He was in a phone booth. Anybody remember what a phone booth is? His subjective expectation of privacy was expressed by him closing that door to the phone booth. And the majority in Katz found that this expectation of privacy was one that society was prepared to accept as reasonable. Now, many constitutional scholars were quite upset at this decision because of the formulation itself. They said this is unmoored in the Constitution. This is subjective, and are we as a court going to decide what society is prepared to accept as reasonable? It's really more of a legislative function, isn't it? The legislature is supposed to decide what society expects and to promulgate laws that represent what society wants at the time, subject, of course, to the Florida Constitution. And so those who have been upset about the right to privacy have long railed at the decision in Katz because it injected the court into policy, more of a legislative act. Now, I'm quite comfortable with the court deciding that there is a right to privacy, but I have always found that there is a property interest here. Always. I mean, even before Carpenter, I would have to run around saying information is property. You've heard me say it 100 times. I know you have. Okay? And I was just ecstatic to read Gorsuch's dissent, because he said exactly what I've been arguing for 15 years. That we don't have to do this expectation of privacy dance. And it became a problem pretty quickly. Okay? Because soon after Katz, the court decided 2 other decisions that ripped away a whole bunch of the protection they had just granted. They created an exception to the expectation of privacy doctrine. Well, even if you have a subjective expectation of privacy, and even if society is prepared to accept it as reasonable, if this information is in the hands of third parties, it's an exception. The third party doctrine. And that was used to allow law enforcement to obtain financial or bank records without a warrant. They could get it on a mere subpoena. It was allowed for law enforcement to do what's known as a track and trace or pen register, which is non-content. Merely the envelope information of a phone call, you know, before the internet. Right? So this third party doctrine just blew a big hole in the privacy rights of individuals. Even though this was very personal information, a lot of conclusions could be drawn from it. And indeed you will find that some of the justices who were dissenting to the cases articulating the third party doctrine, and in particular the Penn Trap case, were saying something that sounds a whole lot like what we now know as the mosaic theory. That information, digital information, even if it's not the content of the communication itself, the stuff that surrounds it, the envelope, the addressing information, the location information, the times, the endpoints, who you're talking to, all of this can convey a bunch of really important and potentially private and sensitive information about you. Who are you calling? You're calling your obstetrician. You're calling your pharmacist. You're calling your somebody of the opposite gender, or maybe the same gender, that's not your spouse. This is all very sensitive information, but it's in the hands of third party. And so as a consequence of the third party doctrine, law enforcement can get their hands on it without a warrant. So, the court struggled with this reasonable expectation of privacy and the third party exception. They were all over the place. The cases, you read them, and if you're like me and you try to draw a line to, you know, and kind of put it in a box so that you can understand, you end up going, they're just pulling this out of their ass. They want law enforcement to get it, or they don't want law enforcement to get it. It's not a very attractive defendant. You know, Lord knows what the reason is. I can't figure this stuff out. So, you know, we all kind of had a hint that what the Supreme Court had been doing in Jones and Riley and some of the other cases that began to take a look at information privacy in the various contexts, and in particular the Fourth Amendment. And we were really hopeful about what would come out in Carpenter. Okay? Now, I was actually somewhat disappointed in the majority decision. Okay? Because they did not just blow out the reasonable expectation of privacy test and return to the old style approach, the constitutional approach, the founders approach, that information is privacy and therefore part of your papers and effects. But what they did say, thankfully, they got the right result, so I guess I'll live with that. That cell site information, carrier provided cell site information, which determines your historical, which can convey your location, is so sensitive and revealing that they refuse to extend the third party doctrine to it. Okay? Trust me. When you start seeing the court saying, we're not going to extend this doctrine to it even though it applies, and all the lower courts have been saying, of course, the third party doctrine applies, you know that they're just playing games with themselves and they're trying to hide something that's going on. Yes?
The Carpenter case or any other case give any sort of test that you can use to determine is this that important enough that they need a warrant, or not important enough that they can just, you know, have it? Do we have any sort of test for that? Like when does metadata or data reach an important enough level that government can't take it without?
In jurisprudence perspective, this is all really new stuff. I mean, we're talking the last 10 years. Okay? So the courts are really still trying to get their arms around this stuff. I can tell you that the Supreme Court in the last 6 years has if you look at the end results, okay, forget the analysis, okay? We lawyers, we use these big words and these big concepts, just like all the Roman Catholic priests used to stand up and talk to the penitents for an hour and a half in Latin. Nobody understood what the hell they were saying, right? Okay? Lawyers, we use Latin for the same reason, okay? Just to make us look important, look high-minded, smarter than you. Okay? What's important to you is the end result. Okay? And the end result is that the Supreme Court is realizing that there's all sorts of stuff out there that the government is able to obtain using new technology. And therefore it needs to be protected. Orin Kerr, I don't know if you know who Orin Kerr is. He's a famous constitutional scholar. I follow him. I read a lot of his stuff. I think he is certainly well qualified, but I tend to disagree with him a lot more than he would probably hope, because he's a bit more pro-law enforcement. He did come up with a good idea, though. He calls it an equilibrium adjustment. When the Supreme Court begins to think that the government has gathered too much power through technological advancement, they do an equilibrium adjustment and give the rights back to the people. And that's what's going on here. Yes?
I have a question to get a more of a speculative opinion. So I understand the ability for compelling of biometrics, since the act of giving biometrics for encryption keys is sort of it's already in the light of day. Your fingerprints are visible, your irises or your retinas are readable, facial recognition, anyone can look at your face. What if the actual data is internal within your body? Let's say I have a chip implanted into my hand that I use the serial number of said chip as an encryption key. Since now this kind of crosses over from things like Riley into McFall v. Shemp, does this now cross into a bodily integrity and autonomy area, or does it still fall within biometrics because now it's breaking the skin?
Is it an RFID chip?
Yep.
Okay, you wave it over there, that's an act.
It's still an act?
It's an act. Okay? Now, if you get your little penknife out
and cut it out,
and cut that chip out, right? And then insert it, okay, well, I don't know. I mean, that's a closer question. Me, I'm not real happy with the way this biometric stuff has worked out. I mean, it is what it is. I think the body talks. And to me, it's testimony. Okay? I think forcible drawing of blood, I think that should be a Fifth Amendment question.
Yeah,
okay?
that would definitely fall under the McFall v. Shemp.
Yeah. But remember one thing, okay? They still got to get a warrant. And that's the ultimate protection. As a practical matter today, this stuff is out there. It is available. The question is upon what terms and conditions can the government get it? And ultimately, the only protection we have is the demand for there to be a warrant issued only on probable cause to believe that the information to be received as a result of the search will reveal evidence of a crime. They got to go before a neutral magistrate. They got to swear out an affidavit upon penalty of perjury. They got to convince this magistrate that this thing that I want is located in a place and it contains evidence of a crime. So, by demanding a warrant, you actually are imposing a fairly significant burden on law enforcement. Okay? For example, just to give you the cell site location information thing, right? It was dealt with in Carpenter. Them simply saying, we have reason to believe that Joe Blow, a guy who committed a crime, is in a certain area. And we want to track him. They have to say that this cell site location, if obtained from the carrier, will reveal evidence of a crime. Not just that he's got a cell phone, not just that he's there, but that him being there is evidence of a crime. So the probable cause standard, as articulated in the Fourth Amendment, is very important, and it does impose a high burden. Now, yeah, can you get a warrant pretty easy? Sure you can, but you still got to swear to something, and there are consequences if you deceive the court. Well, at least there used to be. I don't know. I mean, I was always suspicious of the Foreign Surveillance Court. But some of the things we've learned recently is that it appears to be pretty easy to get a warrant from them. But the Supreme Court, you know, actually does try to pay attention to the practical consequences of its decision. And what they are beginning to understand is that this information can yield very sensitive and private information. Information which is very analogous to the papers, effects, and things that are described in the Fourth Amendment. And therefore it needs to be protected. And yes, this protection should extend beyond just in the home. It can extend and should extend to storage devices, other means where, using the articulation of the reasonable expectation of privacy test, which I hate, okay? We think it's private. We want it to be private. We don't just hand it out for other people to look at. And we certainly don't want to give it up to the government. I think you had your hand up first.
Well, you know, the reasonable expectation thing, everything that we're pounded with every day, whether it's business or government, I have no reasonable expectation that anything I do digitally is private. Zero, zilch, none, and that's actually expounded continuously to completely undermine that particular, you know, standard. There is no standard for that today as far as I can tell.
Yeah, I think that a better way to put it these days is, God, I wish that this was really private. God, I wish I could get some protection from the government being able to get this without a warrant. I mean, with a, you know, I want to have a warrant for this.
I wish it was hard to get a warrant. I wish that when they got a warrant when they shouldn't, something would happen.
Yeah.
To them, yeah.
I mean, yeah, you know, as a programmer, I'll just say the instant you connect a computer to the internet, the data is not private anymore. And frankly, echoing sort of your don't write it down or put it anywhere but your head if you want it to be private. I mean, it's like, even if you have your computer not on the internet, it's still emitting readable electromagnetic signals. They can get it out of there if they want to get it out of there.
Trust me. They're getting it. They get everything. Everything. They do.
Mush.
And those who are telling you that, oh no, it's only the foreign intelligence, we're not tracking them. Bullshit.
Basically,
They get everything.
get inside a Faraday cage.
Okay. So, where are we?
How do we continue an academic discussion when we're like, oh, it's hopeless, they get everything, nothing that we're talking about is true anymore?
Well, but then there is hope. I mean, we just had a very important Supreme Court decision. And one from an Indiana court that actually was trying to ameliorate, you know, an overreach by government. Trying to rebalance individual rights as against the government. The courts are trying. They recognize, as we started from the beginning, that individual privacy serves a useful function. It advances civilized society. It maintains an aspect of individual autonomy and is implicit in liberty. And so, using again Oren Kerr's formulation, they're trying to do an equilibrium adjustment, however they can, using the precedent that they're bound by. More in the Supreme Court, you know, until they can find a reasonable rule. Right? You know? Trying to find a way to protect individual information where it seems kind of reasonable for the government to have to get a warrant. Yes?
The majority of this conversation is sort of built around privacy from the government and kind of how he is mentioning the horses out of the barn as far as privacy in this nation, especially from a consumer privacy perspective. Sort of surprised we haven't touched on any of the regulations such as GDPR. The dominoes are going to start falling on that front. India's next. California's about to pass some legislation. I kind of wanted your take on
They
that.
did pass it as a way to govern,
Like,
governor's signature.
Whether you think, what do you think the correct approach is on the regulation side? Like, who do you think is getting it right? What do you think we're messing up?
I don't think anybody's getting it right.
Do you think things like the GDPR are a step forward, or?
Well, okay, here we go, and this is where I'm probably gonna upset some of you, all right? Okay, this is a libertarian in me coming out. I'm not talking about the government now, I'm talking about as against businesses, okay? You need to exercise some initiative and try to take care of yourself. Take the steps that are necessary to protect your property. Okay, do you paint your house? Do you put a lock on your door? Do you close the door to the bathroom when you go in it? All of these things are things that you do. You learn how to do it. You learn how to protect your property. This is another example. Okay? Now, I will grant you that at present, individuals have damn little negotiating power against these large companies. If I were empowered king to resolve this, what I would do is I would outlaw mandatory consumer arbitration. Okay. I would deem certain terms and conditions unjust and unreasonable, deceptive trade practices, or unfair business practices, especially those where a person is required to waive privacy in order to enter the contract to begin with. I would prohibit companies from changing the term of the contract merely by posting something on some website on the dark side of the moon. And I would do something about click wraps.
About what?
Click wrap.
You can check our lecture with Chris Brown to hear more about click wrap agreements. It's on our website. If
Nobody reads these contracts. And it doesn't do you any good to read them to begin with. Try to change one. You can't. These are not negotiated contracts. You know, the contract lawyer in me looks at this stuff and I go, this isn't a contract. Oh yeah, it is. It's an adhesion contract. This is not negotiated between people. I would return to a more balanced way for people to negotiate these contracts. If I don't want to give up my information, I should try to have some opportunity to negotiate with them about it. But as citizens, we also have some kind of obligation to control our information. Quit giving it away for these free products. If it's free, you're the product. Yes.
I think to extend that a little more though, you've got other nation states with resources and things like Five Eyes, where you've got governments collecting data in other countries and then sharing that with other governments. And so how does privacy as a natural law extend to other countries coming into my country, getting my data and giving it back to my government? Like, do we have any recourse there?
Well, my view of the natural law is, I'm not just talking about my government, I'm talking about any government.
Right.
Okay? And I would hope and pray that my government, the people who are up there governing as my agents, would protect my rights as against some other country.
But
which is
wouldn't
trying
that,
to
wouldn't that
drive
bother
them
us
out.
also if other countries' citizens have natural rights, not taking, like, not scanning all their data and collecting it all, because they have natural rights that we ought to be able to collect everything that they're doing as well?
I think they do.
Okay.
I think they have natural rights too. And quite frankly, as an individual, I should not be wanting to get my hands on it unless they consent.
And just we'll also kind of springboarding on like that we have some sort of responsibilities of safety as citizens. That's why I'm a strong proponent as a software developer programmer of end-to-end encryption. And more than that, there's once again kind of doing a utilitarian argument to privacy and encryption and against backdoors. Every so often you'll hear one of these people say, oh, we shouldn't allow there to be encryption on computers, because bad guys can hide stuff. And I just come at it as a very practical point, which I don't actually hear it made enough, which is, I kind of summarized it recently as for computers to be useful, they have to be dangerous. And the simple truth is the whole reason the computer has transformed our society is it's programmable, that we can make it do whatever we want. But it turns out, and this is built into the laws of mathematics. Once you've created a device that has that kind of power, unless you treat the programmer as an adversary and lock them out of being able to program the device to do certain things that have business, society, utility, unless you lock them out of that, you can't prevent them from creating encryption on that machine. Like, you literally can't. So from a utilitarian society functioning smoothly, for our economy to prosper, we have to make our computers open enough to be useful. And that you can't not have encryption if they're that open.
So as against non-government entities, it is clear that people do not have negotiating power. But on the other hand, you just need to quit giving this stuff away. If your privacy has value, quit giving it away. Control it as much as you can. If it comes to choosing to not use certain things, then don't use them. I don't do Facebook.
Credit cards?
It's very similar.
You don't have credit cards?
I like to carry cash. Okay? I do. Sometimes I have to declare it when I come across one. And they look at me all googly eyed. Okay? Yeah. It's the same thing. Credit cards are the same thing. You've had your hand up, and then we'll do you. And then we'll do you.
Let's think for a second about personal health information. So if we're traveling and we get treated in an emergency situation, it's a very good chance that hospital will not have rapid access to our electronic health records. It has to get faxed from one hospital to another system. That allows them to comply with the federal HIPAA regulations. But it's the case that the big healthcare companies don't want to share data with each other because it's valuable. They use HIPAA and our privacy as the justification for not having interoperable healthcare records. Do you think we have the balance right, or do you think we're letting them use that as a fig leaf argument to not share data?
The job of a corporation is to maximize profits in order to distribute them to your shareholders, consistent with law. And so, any corporation that's in business is going to try to find a way to maximize revenue and profits using whatever means it has profit, including your information. It is just the nature of the beast. Now, another strange thing about me is I don't like corporations. Okay? I think they should be foreign to the law and certainly not treated as natural persons. But, you know, it is what it is. And we just have to understand what this beast is. And, you know, quite frankly, I did a bunch of HIPAA work, especially when the statute was passed. And my first conclusion after reading that immense statute, why can't Congress pass a short statute, by the way? Is it possible to do something in plain English that people can understand and read in like 10 minutes? HIPAA is an exercise in waiver of privacy. That's all it is. First thing you got to look at is the caption of a bill. If it says the puppies and apple pie bill, you know that somewhere in that bill they're going to be killing puppies. Okay?
I think that's the quote of the night right there.
Somewhere they're going to be killing those puppies. And they're going to be stepping on that apple pie. Maybe even banning them. Right? Pay attention to the caption of that bill. If they say we're going to do this to protect your privacy, watch out for your privacy. Wait. I'm sorry, I lost track of who I said this.
It was them first. I had to follow up on what you're saying.
And FYI, keep the questions short. There are 8 minutes till we're booted out of this room.
So earlier you were talking about how privacy is in many ways inseparable from property. But as a society, we're urbanizing, so we're getting in smaller areas. More people are renting. In many ways, we're moving away from private ownership into like public utilities. Like in 20 years, no one will own a car. Instead, we'll subscribe to a service. In many ways, we're moving away from private ownership. And I'm just wondering what do you think the implications of that are? How can we rethink our approach to privacy to meet that change, that really drastic change in how we organize ourselves?
I hope that we don't move away from private ownership. Okay? Because if we lose private ownership, we lose individuality, we lose our liberties. Very we're giving up our liberties to control the government. And Lord knows where that lands. A public utility, I do public utility law, okay? They're still private corporations. They just simply have higher and elevated duties. All right. Renting, even though you don't own that home, you have a property interest in that. Once you sign a lease, okay, you are going into your home. It is protected under the Fourth Amendment because you do have a real property interest. It is a leasehold interest, but it is a property interest. So please, don't give away this property right so casually. The idea that an individual actually owned property was one of the greatest inventions of ordered society around. It is what distinguishes us from slave owners and serfdoms. It is the only way that individual liberty can be preserved. Yes?
Can you talk a little bit more about the Cloud Act?
About the what?
The Cloud Act.
Cloud Act, I believe. Cloud Act. I'm not sure what he means, but the Cloud Act.
It's a new law that was passed in March 2018.
I'm sorry, I'm drawing a complete blank here. I probably know what it is, but I'm just drawing a blank. I'm sorry. A failure. Ending on a fail.
Any last question before we wrap it up for Scott? Anybody?
One of your biggest points was, if you don't want them to know, don't write it down, don't communicate it with anyone. Yet I'm reading why is privacy important and saying advancing the human condition. Isn't keeping it to yourself making it less likely to advance the human condition?
Keeping it to yourself is important. Privacy is an important aspect of having an ordered society. It is part of being polite, respecting someone's privacy. Now, what I said at the tail end was merely practical advice on ways to keep it out of the hands of law enforcement. What I said at the beginning was a philosophical and ethical basis as an argument for privacy. Does that make it?
Yeah.
Okay.
All right, one more.
Yeah, during the HIPAA discussion, it sounded like you were kind of saying that the corporations' need to make profits for shareholders was almost privacy destroying inherently in a way. Whereas I would take a very different approach to it and say that there are companies out there that actually feel like building privacy into the products, actually having like privacy by design built into them
I work for
is
one.
actually a value.
I represent one. Absolutely.
Yeah,
Golden
I
Frog,
work for
Viper
some in the
VPN,
past.
that's their whole purpose. But let's be frank, they're doing it to make money. Right? They're doing it to make
Yeah,
money.
I'm
They
not
just
sure
think
with
it-
that, but it can
something
be
they can
a
say.
profit
Oh,
building.
absolutely.
As well.
And I hope we find a whole bunch more people that realize that there is marketing value and profits to be made through enhancing privacy. You
Right at the
bet.
very beginning, you sort of did a shots fired thing on Verizon, AT&T, and the one I was most interested about was Google, because I would actually make the claim that Google has probably the most world-class privacy team I've ever seen. I'm curious what your biggest issues with them are. My disclosure, I used to work with them, but I don't
Well,
anymore.
I mean, first of all, let me just say, I mean, you know, they're a corporation. Their job is to make money for their shareholders. And if we were to really believe their original motto of "Don't be evil" had any meaning at all, silly us. Okay, silly us. Their whole business model is to suck information from people and then sell it. That's their business model. And so why should we expect anything different from it? You know, if people want to give them that information, I guess they should be able to do so. In fact, I insist that they should be able to do so. Okay? But
I don't think that's fair to call systemically evil just because they collect this data.
I'm not calling them evil. In fact, I don't even think corporations are evil. My problem with corporations is that they are treated like natural persons for many purposes, and that bothers me because they are not.
Evil wasn't the word you used, but when you lumped them in with AT&T and Verizon, you kind of implied that they were really doing some bad things with the data. And I was curious if you had specific examples that you really.
The other thing that bothers me about corporations is the corporate immunity that comes with it. Although I benefit from it because my law practice is a corporation. Okay, I do that because it's the right thing to do. But I don't think that corporations should be able to immunize their share owners from the effects of their doings. I just don't. If people have to suffer the impacts of their actions, then show some corporations and their share owners, which is really what they're there for.
And with that, I think we need to adjourn.
Josh, how you been? Oh, how are you? I walked right by you.
Oh, and everyone,